Hello friends, today the topic which I am going to demonstrate before you is Section 9 of Indian Evidence Act. It is with regard to test identification parade. TI parade value guard against error of identification. The court should approach the evidence of identification with the reasonable doubts of an intelligent person and accept it only if those doubts are removed. In order to remove those doubts, the touchstone to be adopted could be fair, if not good opportunity of the witness for observation, reasonable time within which the identification was made, reliable power of observation of the witness, his credibility, and the fact whether the witness got any opportunity to identify the accused after arrest. The crucial requirement is the satisfaction of the court on the capability and acceptability of the identification. If identification parade was not properly and regularly conducted, it cannot operate as a reliable corroborative or regarding identification in court. This is judgment which says Mohanan Nair versus State of Kerala. This is the point which was being raised in that particular judgment. When the decoyed identification of culprits was made by the touchlight, but the torch is produced for the first time in court without being previously seized, the identification of accused is liable to be rejected. So these are some of the judgments which says how and what precaution has to be taken while conducting the test identification parade. So TI parade and investigation stage. TI parade belongs to investigation stage and is essentially governed by section 162 of CRPC. Whatever been done during the course of inquiry or investigation by the prosecution agency, that will be governed by 162 CRPC. That is a fact of. And with regard to other judgments which says TI parade mode, committing magistrate can hold TI parade for a magistrate committing an accused to session does not decide, only commits the case. If furnishing investigation agency with an assurance that the investigation is proceeding on correct line, and in addition it furnishes corroboration of the evidence to be given by the witness in court, the parade is important from the point of view of both the investigation agency and the accused. Suspect having a mole and 2 lines on the forehead not mixed up with men of similar characteristic, it is valueless. It is one of the judgment. The chart of identification has not been proved by the concerned magistrate who held TI parade, and full particulars of identification not given by him. Conviction on such TI parade is illegal. This is some of the judgments. And one of other judgment is when complainant made no mention of the prominent mark line, deep cleft in the middle of the chin of the accused in the FAR, nor any of the witnesses who did identify the accused mentioned about the mark, and when magistrate holding TI parade failed to conceal the mark, identification TI parade cannot be relied on. Victim witness when given no description of the culprit in FIR, not identifying the accused in TI parade is court, identification cannot sustain conviction. These are the judgments which says what is the mode that has to be considered or not to consider TI parade, what is the situation when it has to be considered. It so happens that sometime the TI parade will be delayed due to some reason. There is a judgment which says delay of 4 months is fatal. Administrative occupation is not explanation. TI parade held 12 months after occurrence, 7 months after arrest. Held delay is fatal. One of the judgment which says what delay is inordinate is a question to be answered by reference to all the circumstances of the case, namely the nature of the offence, the state of mind of the witness at the particular time when the offence was committed, and the duration in which the witness had the opportunity to see the accused. These are some of the guidelines or the judgments which have been given by different high courts, which says what are the precautions has to be taken and what is the actual way that TI parade has to be conducted. The prosecution agency, during their investigation, they will file petition before the concerned court in charge magistrate, saying that they want to conduct test identification in the jail. The magistrate has to visit the jail where the witness will be identifying the person among several members that he is the culprit who has done, he was involved in that particular crime. That is the TI parade which will be done in the judicial custody. And the TI parade, when necessary, it is one of the points which has to be considered during the investigation. If the accused person well known by the side, it would waste your time to pull the accused person TI parade. So TI parade, when it has to be done, what is the way it has to be done? TI parade holding by police department. TI parade surprised by police officer is hit by section 162 CRP and is useless and inadmissible. Police should not be allowed to hold TI parade. This is one of the judgment which says that police should not conduct TI parade. This is nothing but the magistrate has to conduct TI parade, and police people have no authority to conduct such parade. Filing up of TI parade memo, magistrate must fill up the identification memos by his own hand. And TI parade respect of articles, not identical but similar articles should be mixed up with. So these are the some of the judgments which says TI parade identification and Supreme Court interference. The way to be attached to TI parade identification would be a matter for the courts of facts, and it is not for the Supreme Court to reassess the evidence unless exceptional grounds were established necessary in such courts. These are the judgments and the conditions which are supposed to be followed by investigating agency while conducting TI parade. Today I have explained with regard to the TI parade conditions and different judgments which was being given by different high courts. The investigating agency, when they are to conduct TI parade, how they have to conduct the TI parade, and what is the validity of TI parade during the course of trial in courts. So this is the point today, section 9 of Indian Evidence Act, which speaks about TI parade. Thank you very much, friends.